Hold it. Your birthday's the 26th?
Yeah.
Okay, then you're gonna have to come see me on your birthday. Will that be okay?
Yeah.
Okay.
With June 26th,
Yeah.
you're coming back here
Yeah.
for your birthday?
Yeah.
You should not do that, you know?
You want me to get, you know what?
I'm just kidding.
No,
June 26th, thank you, Your Honor.
July 3rd.
Oh, July 3rd, okay.
She can do something else for her birthday. July 3rd, 2025, 9 a.m. Okay. And
Judge,
bond will continue.
will that
You
ti-
get over to community corrections.
Will that time stick? The only reason I ask is she has no phone, no means of,
It likely, well, it may only because you will probably have people in custody.
okay,
So that it's likely to be right around.
so we can set it for 9 a.m.?
Yeah, but I don't, you know how it works with our blocks.
Well, it's just this,
No, I hear you.
okay. Okay, thank you
Okay.
very much for your
Ms.
consideration.
Hall, happy birthday,
Thank you.
since I won't see you.
Thank you.
All right.
Thanks, Judge.
Court calls the case of the people versus Lena Harbali.
If you ever to me, the Assistant Public Defender Hannah Apple appearing on behalf of Ms. Harbali. So what you know? Harbali, please state your name for the record. Lena Harbali.
I have before me a plea form that indicates. I don't know what this means. She's just pleading to the I didn't need a plea form. She's pleading to the stated counts 3 through 5,
Correct.
and 1 and 2 are going to be dismissed, and she's pleading guilty.
Yes.
Solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
I do.
Lower your hand and state your name again.
Lena Harbali.
All right. Sir Bali, it's this court's understanding that you're going to be pleading guilty to 3 counts of malicious destruction of a building. Is that correct?
Yes.
All right. 2 of those counts 3 and 4, are malicious destruction of a building 200 to 1,000. Those are misdemeanors punishable by up to 1 year incarceration, a $2,000 fine plus court costs. The fine could be increased 3 times the value of the damage or injury to the building. If that's greater than $2,000, that would become the maximum fine. You understand that?
Yes.
All right. And count 5, the malicious destruction of a building is less than 200, which is a misdemeanor punishable by up to 93 days in jail, $500 fine plus court costs. That fine could be increased 3 times the value of the property destroyed or otherwise injured. If it's greater than $500, that becomes a maximum fine. You understand that?
Yes.
All right. Understanding all of that, do you still wish to plead guilty? I do have to advise you of one other thing. While I'm taking your plea, I would not be your sentencing judge. You would be sentenced before Judge Perry in the 15th District Court. You understand that?
Yes.
All right.
Sorry, Judge. It would be Judge Valvo, correct, with the mental health?
It would be, but the case assignment that they have, it will go to Perry, but then
They move it.
because she's there, well, then I think they do
Okay.
that there.
Okay. The court 15 sent me dates that they asked from mental health court, but I don't know if I will follow up and change it later.
So they sent you dates that. we can set.
6/18 or 7/2 in front of for mental health court.
Okay. Then
Sorry.
what I'll do is this could get messed up, but I'll make it Valvo.
Okay.
All right. In any event, you'll be sentenced in front of somebody other than me. Okay, all right. And understanding all of that, do you still wish to plead guilty?
I do.
All right. To the charge of malicious destruction of a building 200 to 1,000 as contained in count 3, how do you plead?
Guilty.
To that same charge as contained in count 4, how do you plead?
Guilty.
To the charge of malicious destruction of a building less than 200 as contained in count 5, how do you plead?
Guilty.
You understand that by pleading guilty, you will not have a trial of any kind.
Yes, sir.
You signed an advice of rights form, is that correct?
Yes.
Any question regarding any of those rights?
No,
All right, look at paragraph 5. You'll see a copy on the podium. Those are your rights which are part of a trial. You understand that by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
yes, sir.
You understand you're giving up your right to appeal of right.
Yes, sir.
Are you on probation or parole?
No,
All right. Has anybody promised you anything other than what's been stated here today on the record to get you to plea?
no,
Has anybody threatened you or coerced you in any way?
no,
to get you to plea? Counsel, are you aware of any pleas or promises, threats, or inducements that are causing this plea other than what's been stated here today on the record?
No, Judge.
You're doing this voluntarily
yes, sir.
and of your own free will?
Yep.
Okay. And because you believe that you're guilty of these offenses?
You have to say
was.
yes.
Yes,
All right. On the date or between the dates of March 19, 2025 and March 24, 2025, at the location of 312 West Huron Street, City of Ann Arbor, Washtenaw County, State of Michigan. What do you do? Well, actually, it's going to be different buildings. It's actually 304 South Ashley, 300 South Ashley, and 308 South Ashley. At least as is contained in the report here. What do you do to those buildings that makes you think that you're guilty of these offenses?
Judge, may I have one here?
Yes, please.
Thank you. Ms. Harbali, on the locations listed on those dates and times in March of this year, did you go to the Fleetwood Diner, the diner next door, and then a retention wall there? And did you mark those with graffiti?
yes,
Okay, and you did not have permission to graffiti those locations and those buildings and that property?
no,
Okay, and would you agree that the damage that you caused from the graffiti has a value of $200 to $1,000 for each of at the Fleetwood Diner and the diner next door to it?
yes,
Okay, and as for the retention wall, would you agree the damage was less than $200?
yes,
No.
Defense is satisfied. I think covered everything.
Ma'am, I do have to advise you that if the judge, the sentencing judge, Judge Valvo, does not follow any prosecutor sentence regarding recommendation, you're not entitled to withdraw your plea. The court further has to advise you that if between the date that I accept your plea today and the time of your sentencing, that if you commit some type of misconduct, that you're also not entitled to withdraw your plea unless allowed by the court for good cause. You understand that, ma'am?
yes.
All right. Has the court complied with the court rule? Would it be proper to accept this defendant's plea?
Defense is satisfied.
Court will accept the defendant's pleas of guilty. 2 counts 3, 4, and 5. Counts 1 and 2 are dismissed. Pre-sentence investigation and report is ordered at 15th District Court probation. Sentencing in this matter, and what was the date you had? I'll just do that.
I think based on the interview, July 2nd would be,
July 2nd.
yes, that was the date that was given.
July 2nd, 2025. It's at 9 a.m.
They didn't provide a time. We'll say 9 a.m. and I'll confirm.
All right, 9 a.m. and that's before Judge Valvo. I'll just mark on here, mental health court. You see, I'm changing it. All right, your bond will continue. Thank you. Good luck to you.
Thank you.
Close the case, People versus Valerie Robinson.
Good afternoon, Your Honor. Edward Drukas on behalf of Valerie Robinson.
She in Zoom.
She is, Your Honor. No.
Valerie Robinson?
Yes,
All right, state your name, please.
Valerie Dari Robinson.
All right. Okay, what are we doing?
I'm asking for a preliminary examination,
All discoveries complete.
to my knowledge.
People would have their witnesses available the 24th.
Do our best, Your Honor.
Preliminary examination in person will be set June 24th, 2025, 9 a.m. That's before Judge.
For sure.
Before
Hey, folks. Yeah. Hey, people came over. That's really nice. Thank you, Live TV, Tribe TV Live. Yeah, I'm currently, because StreamYard is down, EVMux is down, but it seems like I got Rumble Studios going, and I haven't used Rumble Studios for well over a year. So I'm currently streaming something while I'm trying to figure this crap out, okay? Oh. So, what else but checking out Judge Simpson while I'm trying to figure this platform out? Thank you, everybody, for being here. Hit the thumbs up. Do all the YouTubey things. Do all the YouTubey things while you watch Judge Simpson do his thing, and look at me while I'm desperately trying to figure out something that means I have to do something with the computer. Hello, folks. I don't need an overlay. Oh, wait a minute. Look! I can show individual. I couldn't do that for a year. Hello, folks. Hello, Deborah. Yeah, as I said, StreamYard and EVMux down, testing Rumble Studios. Seems to work. Hello. Glad you're all here. And yeah. Yeah, that thing. Okay, let's continue to watch Judge Simpson while I desperately try to figure this platform out.
Judge Freshour. Bond will continue.
No,
Thank you, Ms. Robinson.
tell them you handicapped, you can't go. They don't know you handicapped.
I told him.
How you gonna get there?
I told him. Hello?
Hello.
Yes, I had a stroke in October. I can't get to the courthouse.
Okay.
That's
No worries.
the-
I was aware, and she indicated that she could get to the courthouse in a wheelchair. I don't
If
know
I
if
can get it right, that's if, keyword if.
She ain't got nobody with transportation.
I just got lucky that day.
I can be in communication with the prosecutor's office if
All right.
adjournment's needed, but I think
Okay.
that's enough time to see
Figure it
Friday.
out.
Yep.
Okay, I'm gonna leave it set. Talk to your attorney about that and see how we're gonna get that worked around, okay?
Okay.
All right, thank you, ma'am.
Thank you.
Mhm.
Hi, Squeaky. No, I'm
Court does
just
call the case,
hosting
People
the
versus
stream,
James Taylor.
even though it looks like I'm part of the hearing.
Edward Lucas on behalf of James Taylor.
Is he on?
He is not on, Your Honor.
Okay, so you just walk off? Okay, well, thanks for letting me know. It's really nice. You guys go ahead and have your conversation. I'll just sit here and wait.
I'll let Mr. Curtis play.
Everything that he put, okay, all right. I don't know why he had to whisper it to you. We all. He was determined to have a conversation with you though. But
I was, Your Honor. Actually, I'm asking for an adjournment today. I'm trying to find out what actually is going on. He is in the hospital, and I believe he's in Spera Hospital up in Lansing. And
you think he is, or you?
I have received this information from a family member, and he may be being detained there while he's.
I'll need a green sheet and I'll adjourn it out.
I got an overlay in.
That's fine, Your Honor, and I was just, Mr. Lucas, when he was whispering to me, also mentioned that he may be under the detention or.
Hey,
supervision
recovery
of
addict is here as well.
jail.
Hello.
So just ask
Not-
if Mr. Lucas finds out that he is housed the county jail to let me know. So
Hey, good to see you. Good to see you.
Thank you for sharing.
It seems like
I was
the
gonna
only
show you- I was gonna
platform
share it.
working at the
No, you
moment
weren't gonna
is
share that.
Rumble
You made some,
Studio.
he's in the hospital and he's just weren't gonna mention that part. were you?
Trying to use some positive facts and get an adjournment. I just got discovered.
I'll let it go this time.
Thank you. Have a great day.
Can I send links?
Court calls the case, People versus Serrano Johnson.
Stephanie Can on behalf of Mr. Johnson. Mr. Johnson, when you're at the lectern, please state your name for the record.
Serrano Johnson.
Your Honor, we are requesting a two-week adjournment to do some negotiating on this particular matter.
All right. That objection, June 26, 2025, 9
It wasn't
a.m.
me.
Is there anybody
I
who
was
kicks?
not in charge of internet
Fine, we'll
today,
continue.
and
Thank you,
with a good
Thank you
reason.
so much, Your Honor.
I'll call you like I did before, okay?
Court does call the case, People versus Anthony Lafredo. What, did I surprise you or what?
Anna Mackey on behalf of Mr. Lafredo. Your Honor, I checked X jail and it looks like after he was released from Washington County, Jackson County ended up picking him up. So he's currently in that jail. So I'd ask this court for an adjournment, Your Honor.
You're not gonna do a jerkus. Is there something else you can tell me?
No, sir.
All right.
Oh,
You think he's in Jackson?
what's funny about this particular attorney that is way up there to the left is she is relatively new to this courtroom, and she's from New York, and she desperately tried to get her a few weeks ago. She desperately tried to get an adjournment for her client because he is on the bus. He's on the way here. He's not actually skipping this hearing. And Judge Simpson had so much fun with her because she was so desperately trying to work something out for her client who was on his way. And you could tell she was from New York because she said, it's a very slow bus. And yeah. So I will try. I have some clips on my Trial Watch Clips channel with Judge Simpson. And with this particular attorney that you see on your top left, and they are having so much fun, and he is giving her such a hard time for being a rookie attorney in his courtroom.
I know he's in Jackson.
All right, I'll adjourn this out in probable cause conference, 26, 2025, 9 a.m.
Thank you, Your Honor.
Overlay is a bit too distracting.
Thank you.
Court calls case People versus Dwight Miller.
Ashley Lonnie for the people.
And Assistant Public Defender Jay Bellinger on behalf of Mr. Miller, who approaches your.
It was the bus from Detroit to Wichita. Oh, I don't remember which court.
Can you please state your name for the record?
Dwight Miller. Thank you.
And Your Honor, my belief is that my client does want to set this for preliminary examination. However, I am uncertain. He and I have had some conversations, and frankly, I believe he wants to make some statements to the court. I advise him against it, but at this point, I think he wants to talk.
So we're understanding this is a criminal matter, right?
It is.
Okay, so basically, man, it stemmed from a falsality. All this whole thing, I was falsely arrested, something I never did. I got a sworn affidavit.
Sir, I'm sure your counsel has advised you. I'm going to advise you to not say anything else about the subject matter of the case.
Okay.
If you'd like it set for preliminary examination.
I want to challenge jurisdiction.
Say what now?
Jurisdiction.
Yes.
Of whom?
Y'all have a jurisdiction of a case that doesn't exist.
Oh, we have a sovereign citizen.
On what grounds?
What crime did I commit?
Pardon?
What crime did I commit?
Allege that you committed the crime.
I didn't
but
commit that crime.
resisting. If you want to interrupt me, I'll answer your question. But if you want to keep interrupting me, I'm not going to play that way. I'll answer your question. You're accused of the crime of attempted resist, or not attempted, but resisting and obstructing a police officer.
So we all aware that this never transpired, right?
I am not aware of that.
Okay.
Oh, this is going to be fun.
That all you have to say?
Yes, sir.
So, Your Honor, I would ask Mr. Miller. Mr. Miller, I'm not submitting frivolous motions.
Can I get my affidavit put in on the record, please?
Affidavit.
My affidavit of the incident that transpired.
Your affidavit of what?
The facts in the case. My statement of what happened. Can I get it on the record?
There will be an opportunity if you so choose, if this goes to a further proceeding, for you to put whatever evidence you want into the court. But this is not the time to do that.
Really? So when is the time to put the evidence in there?
If you want it set for a preliminary examination, you'll have that opportunity. And if it proceeds to trial, you'll also have that opportunity.
So once again, I'll ask, do you want to set this for preliminary examination, Mr. Miller?
Sure.
Thank you.
Not really.
See, do you want to set it for prelim or do you want an adjournment?
Preliminary examination.
Thank you.
To your knowledge, all discoveries.
To my knowledge, yes, Your Honor.
People have their witnesses available the 24th.
Yes.
We could try for that date, Your Honor. If possible, I might ask to go one. No, let's do that date. Thank you.
All right. Preliminary examination in person will be set June 24th, 2025, 9 a.m. That is before Judge Washington.
Thank you, Your Honor.
Thank you.
You want to get this camera? They will have it ready.
Oh, that's it. Oh, I was hoping for more, but yeah, you could see it even on the other people on the screen. That, oh boy, this is oh no. Recovery addict lawyer client meetings must be a joy with this one. Yeah, he is having the time of his life. Oh. Yeah, and the attorney on the bottom right, yeah, he was having problems containing his laughter at points. Oh, I did not expect a sovereign citizen today, but hey, here we are. Here we are. Me trying to figure the Rumble Studios out while looking at Judge Simpson.
Court does call the case. People versus John Michael Nowak.
Alex, on behalf of the people, Your Honor.
Oh, that was fun.
Kevin Audition on behalf of Mr. Nowak, stepping in for attorney of record, Chelsea Burgess. Standing for the record. Your Honor, we were going to be asking for a brief adjournment to continue plea negotiations with the prosecutor's office.
Yeah, I love checking in on Judge Simpson. The problem is that he deletes his streams after a while. And so what I've been doing is I've recorded all of his weekly proceedings. And then on Saturdays on my Trial Watch Clips channel, I cut out all the pauses, all the breaks, all the stuff. And it is between 5 and 7 hours of continuous Judge Simpson on Saturdays on my Trial Watch Clips channel. So if Gigi could put the link in the chat so people can get over there and get over there and subscribe and watch that stuff. Because if you're not fast enough, you're missing out. And there's a lot of clips out there, but I have a bunch of those too. But I really enjoy spending a full day just listening to Judge Simpson conducting his courtroom like a damn pro.
Without objection, probable cause conference, June 26, 2025, 9 a.m. Bond continued.
Thank you, Your Honor.
Thank you.
Also, without you.
Court calls the case, People versus Timothy Pennington.
Ashley, for the people.
There it is. Thank you, Gigi.
Your Honor, Hannah Mackey on behalf of Mr. Pennington, who should be appearing via Zoom. Nope, actually to my right, Your Honor.
I will.
But
Please state
apparently
your name.
left the other parts of his pants someplace else.
I'm sorry, do I need to wear pants?
Pardon?
Do I need to wear pants next time? Instead of shorts?
Yeah.
Okay, sorry.
Yeah, well, just bring the whole pants set. That's all I'd ask. Go ahead, Ms. Mackey.
Your Honor, we'd like to set this matter for preliminary examination and all discovery is complete as far as we are aware.
People have their witnesses available the 24th.
Checking right now, Your Honor. We'll try for that day, thank you.
Preliminary examination in person, June 24th, 2025. 9 a.m. That is before Judge.
Sure.
Rush hour. Bond will continue.
Thank you, Your Honor.
Judge Simpson, he can barely hold himself together at times.
You didn't tell him to wear the whole pants? What?
I like the shorts, it's not out. Needs to be comfortable.
Okay, so I'm going to assume your next client that walks up in shorts that you told them to do that. All right, that's what I'm going to assume. I'm not even going to ask a question. And then you know what's going to happen? Both of you are going to go, but I think they got bail money for you.
You're keeping me on.
What? What'd you say?
I said she's not in the union, we don't.
Wow. Guess that's a problem.
Oh,
you guys have not been friendly to each other. No, you really haven't. Where's my one intern that was throwing everybody? There you are. Throwing everybody under the bus. People of the state of Michigan versus John Riggs.
Ashley Lonnie for the people.
Mr. Riggs is Hannah Mackey on behalf of Mr. Riggs, who is appearing via Zoom. Mr. Riggs, please state your name.
John Riggs.
Probably got shorts on. Go ahead.
Your Honor, we are requesting an adjournment in this matter. We are awaiting sobriety court to get back to us about his eligibility.
Sorry, to sobriety court eligibility?
Yes, Your Honor.
Have you been interviewed by them yet, sir?
No, I haven't.
You haven't? Okay.
Your Honor, if the court recalls, I think we talked about this last time, he was in sobriety court and then picked up this new OWI, so it was just a question of whether or not he's gonna be able to come in on the new case.
Hey, Hunter.
Oh.
So
Okay.
that's kind of like, I think what's holding us up right now, if I recall correctly.
All right. Let me
Yes,
adjourn it
plans
then,
for prison.
Mr. Riggs, to July 3rd, 2025, 9 a.m.
Thank you, Your Honor.
Try to get everything straightened out. All right, sir?
Thank you. Yes, sir.
All right, thank you. On, continue. Court does call the case, People versus Alexa Russian.
Before we listen to that, Judge McBurney out of Atlanta had this was in the end of April. A sovereign citizen who was supposed to go on trial for a double homicide. And it should have started the week after. But I guess it didn't start because that sovereign citizen had a mental evaluation and haven't been heard from since. Judge McBurney, that's a judge, also one of the judges I really, really like to watch in my spare time. Also, he has he has a deep bass voice that competes with Recovery Addict. And there are so many judges out there, and I want to watch them all. And hopefully I can show you more of that stuff, but as of now, I'm covering. There's a new RICO trial in Fulton County against Cash Out, with Prosecutor Love is the lead prosecutor, and they had opening statements 2 days ago. No, yesterday. And then she was asked to bring her first witness, and she forgot to line up her witnesses for the day. Yeah. So that will be a fuster clock of its own that will be a fuster clock of a trial, and it's a RICO trial. And so I will be covering that going forward. It is going to last a month, depending on if Prosecutor Love can get her witnesses in order. All right, let's get back to Judge Simpson.
Okay.
And Assistant Public Defender Nick Bukovich on behalf of Ms. Washington, who should be appearing via Zoom.
I'm here. Sorry, I had to figure out how to. I'm sorry. I'm here.
It's okay.
I had to figure out how to cut it on.
Can you please state your name for the record, Ms. Washington?
Sorry, Alexa Russian.
All right. Thank you. At this time, Your Honor, we will be requesting a brief adjournment to allow for more time for negotiations with the people.
June 26, 2025, 9 a.m. Bond continued.
Thank you.
All right, thank you, Ms. Russian.
Thank you, Your Honor.
Oh.
But she didn't have her green sheet ready? No, get it from her. I'll take the time and just fill it. It's fine. You're welcome. Court does call the case. People versus Derek Shipman.
Brian Bowling on behalf of Mr. Shipman, Your Honor. Oh, Derek. State your name for the record, please.
Derek Shipman.
Oh, sorry.
Derek Shipman.
Thank you, sir.
Judge, I'm asking for an adjournment. Ms. McDuffie and I think have resolved the issue with respect to the video discovery, and I just need to get it and watch it.
Okay, good. Probable cause conference, June 26, 2025, 9 a.m. Bond continued.
But I.
Thank you, sir.
Thanks, Judge.
It's not that uncomfortable. See, he's got all clothes on and he's just fine, Mackie. Court calls the case, People versus Romeo Serba.
Andrew Childers appearing on behalf of people.
Emma Dadish on behalf of Mr. Serbo. Romeo, can you say your name for the record?
Romeo Serba.
Your Honor, we are going to be setting this for preliminary exam.
All discovery is complete.
Yes, Your Honor.
People have their witnesses available the 24th. Preliminary examination in person, June 24th, 2025, 9 a.m. That is before Judge Washington. Bond will continue.
Thank you, Your Honor.
Thank you.
Thank you.
Case of the People versus Kevin Stevens.
Stephanie Cannon on behalf of Mr. Stevenson, who is approaching. Am I right? Mr. Stevenson, could you please state your name for the record?
Kevin Deshaun Stevenson. Hey.
Yeah, hands.
Wait.
And Your Honor, we would,
Why are you doing that?
What is that? What is that?
we would have it say, he just came in.
He's Kevin Stevenson.
I can't help that. Not my fault. Don't blame me.
We're just asking for it to be set for PE.
What happens to the little person?
Oh, he's back there.
He is so behaved. Oh my gosh.
Excuse me?
He is so behaved.
Okay.
He's-
Sure.
We're gonna set it for PE, Your Honor.
And you are not right. People have their witnesses available the 24th.
That's fine.
Preliminary examination in person will be set June 24th, 2025, 9 a.m. That is before Judge Fresh Hour.
Where's that at?
It'll be here at 9 a.m.
Oh. Thank you.
Thank you, sir.
Where is
Court calls the case, People versus Colin Vandermute.
Actually, a lot of good people.
An attorney, Carol Rosengren, under the supervision of APD Hannah Apple, on behalf of Mr. Vandermoot, who should be appearing by Zoom.
So,
That's unfortunate, Your Honor.
Miss Apple? Why are you looking at Miss Apple? Because she told you he'd be here via Zoom, didn't she? And now, you know what happens? She's like slinks up there. And she's gonna ask me, can you pass it? And can I call him?
I wasn't gonna ask that.
Okay, go for it. Go
I
ahead.
was gonna ask for an adjournment. Mr. Vandermute is in a behavioral inpatient center. He's been appearing via Zoom from turning leave. I always communicate with the case manager and send the Zoom link this time. I don't know why they're not on today, but considering all prior appearances, I would ask for consideration of an adjournment. We're waiting for him to go to the forensic center. It's been months and I don't have an update. Our office did try to find an alternative, but unfortunately that was not successful.
Got it.
So now we wait.
Any objection to the adjournment from the people?
No, Your Honor.
Probable cause conference will be adjourned July 3rd, 2025, 9 a.m. or adjourned by.
Oh. And dump.
You are, I've been in communication with Detective Zachary Allen.
And
regarding
jumping
this
up to the next
case.
stream
We've got a
because
couple of
that
stops
stream
today,
from
Liz
Judge
today.
Simpson
So
ended
we are
abruptly.
looking for an adjournment
But I have
to
another
continue
one.
Talking about
Yay!
the case. Mr. Simon, you're.
I am
Ms. Lonnie actually got
prepared.
them to me live time, Your Honor, as she received them just now. And that is accurate. But asking the court to adjourn the PCC, I know, to 7/17. Here's why. The same unavailability. Same unavailability. Mr. Tompkins has a travel request.
He what?
Has a travel request.
After you make me try to move this up to the 17th, now you want me to do something nice?
Yes.
Probable cause conference, July 17th, 2025, 9 a.m. Yes, Mr. Simon, that's the travel request.
My client has family in South Carolina. He's driving, he's taking a pre-planned trip by car, if the court will permit, from July 7 through July 11.
To South Carolina.
Yes.
What part?
Greenville and Charleston.
Okay. As long as it's that part, I'll let him go. No. All right. You'll be traveling the 7th and the 11th include your travel days. Sir. Correct. Any objection from the people?
No, Your Honor.
Defendant may travel to South Carolina July 7th, 2025 through July 11th, 2025 inclusive. All other respects, bond will continue.
Thank you, Your Honor.
Court calls the case People versus Matthew Newton.
Jeremy Glick on behalf of Mr. Newton, who is approaching the podium. Can you state your name?
Matthew Newton. Thank you.
And Your Honor, before we begin, can Ms. McDuffie and I please approach briefly?
You can.
Thank you.
All right.
Thank you, Your Honor. The defendant would request a brief adjournment to continue discussing resolutions with the prosecutor at the time.
July 3rd work for you.
July 3rd would be great. Thank you, Your Honor.
Probable cause conference will be adjourned without objection July 3rd, 2025, 9 a.m. Where's your invite indicate? Bond
I'm
in
going
this
to
matter
take a
with its
course in
conditions.
how to
Great, thank you, Your Honor.
work with Rumble Studios.
Court does call the case People versus Michelle Love.
Can I put this up again? Hey, so
Exactly what I was going to say.
I learned how to do an
John
overlay.
Shea, Your Honor,
Yay.
on behalf of Ms. Lobaz. Your Honor, this is a case that is dense with discovery, and there's additional discovery that is on the way, which we have requested and which Ms. Reiser has been gracious enough to push forward. But it's going to take a little time to get, and then it's going to take a little time for my people to review it, my experts. So we're asking for, I was going to ask for 4 weeks, Judge, but July 10th, I believe I'm going to be back down in Florida with my parents.
Okay.
Dealing with issues. So if we could have the 17th, that'd be great.
17th will work for you then?
Yes.
Any objection from the people?
No, Your Honor.
Probable cause conference July 17th, 2025, 9 a.m. Whereas your invite indicates, bond will continue.
Thank you, Your Honor.
Thank you, Your Honor. Is that it for you, Mr. Shea?
It is, Judge.
Can you approach it?
Sure.
No, Judge Simpson, why did you mute? Why did you mute yourself? Why did you mute yourself? Here we go again. We have sound. Yeah, so as I said,
Go to your right a little.
I
To your
record
right.
all of your
Good afternoon, Your Honor.
speeches
My
throughout
name
the
is
week
Tim
and
Hemsick.
present
I'm here
it
on
on
behalf of Kathy
Saturdays
Johnson, the defendant here.
as a
Your
continuous
Honor,
stream.
she has gone over the advice of rights. She understands what she's doing, and she's ready to proceed with the plea.
Court has before a plea form that indicates that the defendant would be pleading. It doesn't say how. Is she pleading guilty or no contest?
Guilty.
She'd be pleading guilty to the charge of operating while intoxicated, second offense, 1 year charge. Upon her successful plea to that charge, count one would be dismissed. That's the court's full understanding of the agreement. Is that correct, counsel? Is that correct, sir?
Your Honor, I can barely hear the court.
Okay.
I'm sorry.
No, it's okay. Did you need some assistance?
Not really, Your Honor. I just,
Am I
you
talking
were,
quietly?
yes, you were
I've
talking
never
very
been-
quietly.
I've never been accused of that. All right. So I just went through the plea form that indicates that she's gonna plead guilty to the charge of operating while intoxicated, second offense, a 1-year offense.
That is
On-
correct.
Upon her successful plea to that charge, count 1 would be dismissed. I then asked whether that's the court's full understanding of the agreement, and I asked whether or not that's correct.
Yes, Your Honor.
All right, very good. May I have her sworn?
Raise your right hand. Do you solemnly swear or affirm the testimony you're about to give? True self you got.
Yes, ma'am.
Go ahead, lower your hand and state your name.
Kathy Renee Johnson.
All right, Ms. Johnson, it's this court's understanding that you are going to be pleading guilty to the charge of operating while intoxicated, second offense. That is a misdemeanor punishable by up 5 days to 1 year in jail, community service, and any rehabilitative programs the court deems necessary. I should also say an up to $1,000 fine plus court costs. You understand that?
Yes, sir.
The court could also order your vehicle immobilized, could order you to pay the cost of the prosecution as well as the cost of any emergency governmental services. You understand that?
Yes, sir.
All right. And understanding that, do you still wish to plead guilty?
Yes, sir.
And to that charge, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you will not have a trial of any kind.
Yes, sir.
All right. You signed an advice of rights form today, is that correct?
I just, no, I haven't signed.
Yes, the document we just signed.
Yeah. Said I was pleading guilty, yes.
Okay, but you signed this advice of rights form?
Yes.
You have any question regarding any of those rights?
No.
Please look at paragraph 5. You'll see a copy on the podium. Now, those are your rights which are part of a trial. You understand that by pleading guilty, you're giving up those rights as well as all the rights contained on that form.
The rights we went over, you understand?
Yes.
You understand you're giving up your right to appeal of right.
Yes, sir.
Are you on probation?
No, I'm not.
Okay, are you on parole?
No, I'm not.
All right. Has anybody promised you anything other than what's been stated here today on the record to get you to plea?
No, sir.
Has anybody threatened you or coerced you in any way?
No, sir.
You're doing this voluntarily
Yes, sir.
and of your own free will?
Yes, sir.
I can find the paperwork. On the date of November 16, 2024, at the location of Packard Road near Deek Avenue in Pittsfield Township, Washtenaw County, State of Michigan, were you operating a motor vehicle?
Yes, sir.
Prior to operating that motor vehicle, had you consumed intoxicating liquor?
Yes, sir.
What did you have and how much?
I don't know how much. I had alcohol and marijuana in my system.
All right. Were you stopped by the police or was there an accident?
There was an accident.
All right. What happened?
I was turning around and my phone had dropped and I hit a pole and my airbag came out and the police came and they asked me to take a breathalyzer or whatever and I did all that.
Okay.
And then they asked me, okay.
So the police did arrive.
Yes, sir.
You were ultimately arrested.
Yes, sir.
All right. And you were taken to the hospital?
Yes, sir.
And there was a blood draw?
Yes, sir.
And what were the results of that blood draw?
Your Honor, counsel would like to stipulate the results that we have are Delta 9 THC 2.9 nanograms per milliliter of blood, as well as the cocaine from metabolite. I just can't say that word, but that was detected as well. I understand that's not actually a controlled substance with metabolite remaining. And the alcohol in her system. No, alcohol was detected, but there was a PPT on scene of 0.2 something, I believe.
Say that again.
Ms. Johnson mentioned that she had alcohol in her system. Alcohol was not detected per the blood test. However, the PBT on scene showed a 0.029. I think that's what she may have been referring to when she said alcohol.
Okay. All right. So you had cocaine metabolite as well as THC in your system.
Yes, someone had, when I smoked the marijuana joint, I guess it was the marijuana joint.
Okay. Do you have any reason to dispute those test results?
No, sir.
All right. Had you previously been convicted of operating while intoxicated on or about August 7th, 2003, and or operating while impaired by liquor on or about December 10th, 2021 in the 14A2 District Court for the last one in 14B District Court?
You said 2021? No,
I'm sorry, 2001.
Yeah, 2000 and 2003 is the times I recall being, maybe it was 2001 when I got finished with everything.
The other one. Okay.
20-some years ago, yes.
But you, yes, I know. But you have those convictions. Is that
Yes, sir.
very good. Counsel, have there been any promises that council's aware of that have not been stated on the
I'm
record?
just going to step away. Get
Yes, Your
something
Honor.
to drink.
Court's complied with the courtroom.
Well, no, I'm asking, have there been any promises or other?
Oh, no, none. None, Your Honor. She went through the screening to see if she could get into a program. She's already in a different program, but no promises whatsoever.
All right. And no threats that you're aware of that induced this?
None that we're aware of, Your Honor.
All right. Is that correct?
That's correct, Your Honor. Just to clarify, the promise was essentially that Ms. Johnson needed to complete the screening process, not necessarily contingent on her acceptance and enrollment. So she has fulfilled that end of the promise. She was not accepted to.
I'm having Pepsi in a Coke
That's the only thing
glass.
that was contingent. I refer to call.
All right. Very good. All right. And ma'am, well, and has the court complied with the court ruling? Would it be proper to accept this defendant's plea?
Oh, thank you.
Yes, Your
DSN.
Honor.
I missed
All
that
right.
one.
Ma'am, before I accept your plea, I would have to indicate, and I am the judge, that if there is not a prosecutor's recommendation, but if there were one and I decide not to follow that you are not entitled to withdraw your plea on that basis. You understand that, ma'am?
Yeah.
Why can't I show? Because DSN just made a generous donation over at YouTube. Thank you for a $5 sticker with a pear saying "Keep it up." Oh, there it is. Oh, all. But I can't show it. Why can't I show it? That's not nice. Come on. Well, Gigi says, thank you for the super sticker. But I don't know why I can't show it. All right, but thank you so much. Thank you so much.
Yes, sir.
Also, I have to advise you that if you do commit misconduct after this plea is accepted here today, but before sentencing the defendant, you are also not entitled to withdraw your plea unless allowed by the court on good cause. You understand that?
Yes, sir.
All right. Court will accept the defendant's plea of guilty to count 2. Count 1 is dismissed. Pre-sentence investigation and alcohol screening and assessment is ordered at 14A1 probation. Sentencing will be
July 9th, 2025 at 9 a.m.
July 9th, 2025, 9 a.m. That's before me.
Thank you, Your Honor.
Thank you, sir.
Bond with its conditions will continue. Thank you.
Okay. So we'll see you out in the hallway in a minute. I gotta grab my briefcase.
Court does call the case. People versus Anjay Yancey.
Good afternoon, Your Honor. Gabriel Lacey, P79685, for Ms. Yancey, who is also here via Zoom.
Hello, Your Honor. This is Angela Yancey.
Okay, there you are. Okay. All right, what are we doing?
Thank you, Your Honor. At this time, I am going to ask the court, I got a response from the prosecutor in regards to a proffer, but I was going to ask the court for one additional adjournment of the PCC. I do want to do a letter of deviation for Burton Harris and Mr. Sabat.
I'll adjourn this then to July 3rd, 2025, 9 a.m.
Thank you, Your Honor.
Thank you. Bond, continue.
Thank you.
Thank you.
Overlay is.
Court does call the case. People versus Cyrus Abadi.
Good afternoon, Your Honor. Uwe Dalswithen on behalf of Mr. Abadi, standing to my right. Cyrus, please state your name for the judge.
Good afternoon, Your Honor. Cyrus Abadi here.
All right.
We're here for public cause conference, Your Honor. There's a green sheet. We are winding down discovery in this case. However, there's still 2 remaining items that are missing and we are holding out for, we're looking to adjourn for 2 weeks for that purpose.
Any objection?
No.
Probable cause conference, June 26, 2025, 9 a.m. Bond.
Very good. Thank you.
Thank you.
Court does call the cases of the people versus Marcus Allen Earl.
AP Richmond, people.
And good afternoon, Your Honor. Brendan Dabolsky appearing on behalf of Marcus Earl. Mr. Earl, I believe he's on Zoom, Your Honor. I saw him in the lobby, I guess.
I'm sorry?
Mr. Earl appears to be on Zoom. However, he's non-responsive. And Your Honor, if you recall, a few weeks ago, I was in the court and I had indicated when it was set for the last PCC that there was some serious difficulties with myself communicating with my client. And I think that all stems from some mental health issues. I have spoken to his mother numerous times at length. I think she's the one that signed in today. And unfortunately, my efforts to communicate with my client have been unsuccessful, and I'm at a standstill right now. I do apologize, Your Honor, but there's no way for me to communicate with him, and I was going to make a referral today.
The individual that, it looks like it's Vicky Earl. Did you unmute?
Yes, I'm there.
Okay, what's your name?
Vicky Earl.
Okay.
And I'm Marcus Earl mom. And he has
Okay.
bipolar schizophrenia. And he is not in his right mind right now. Reason he's not communicating with Attorney Brandon right now. And I tried to have him admitted at U of M into the psychiatric ward. He needs some medication so he can stabilize himself, because he doesn't recall any of the incidents of assaulting anyone.
That's okay, ma'am. I don't need you to get that far into it. But is he there right now, or
He is, and he's laying down. The only reason I didn't go bother him because he gets all
Got it.
in a rant.
I got you. All right. And counsel, you're
he really
requesting
needs-
a forensic evaluation.
That is correct, Your Honor. And I know that I would be requesting a criminal responsibility as well, but I believe based on the last time we were in court, you said that would have to come, after this stage. But if we can do both at the same time, I'd greatly appreciate that.
Well, I'll order a forensic evaluation and let them decide which ones they will do. Usually they'll do the competency hearing. I'll then set a competency hearing date for
September 4th at 9 a.m.
September 4th, 2025, 9 a.m.
Your Honor, the only wrinkle here is that Mr. Earl had a new case that would be in warrant status. I understand no warrant on this case, but I just wanted to make sure they're aware as well that that would be up there.
I was going to get to that.
Okay, thank you.
Your Honor, before you address that, I do apologize. The one date I have in my book for early September is September 4th, and I'm scheduled to be in court all day that day. Can we move it to the 11th? Is that possible?
September 11th.
Thank you.
2024, 9 a.m., or as your invite indicates. On that case, bond will continue. Since, quite frankly, at this point, he's also not in, there's another case, counsel, fleeing and eluding, third reckless driving and DWLS that's been filed against him. However, he's not in a position clearly, based upon what's been the court, to be arraigned on that matter. So what I'm going to do is on that case, I'm going to adjourn the arraignment in that to the September 11th date. 2025 at 9. All right. And that way if we can deal with them at the same time, we'll deal with them.
Thank you, Your Honor. And just for the record, Ms. McDuffie did bring that to my attention beforehand, so I knew about that, and we just obviously you answered the question, Your Honor. Thank you very much, and hopefully we get that report done, and I'll see you on September 11th. Thank you.
You'll need counsel. You'll need to get an order over regarding the forensic valuation to the court immediately if you can.
All right. Is it fine if I get it by the end of tomorrow? Is that sufficient?
That'll work.
All right.
That'll work.
Thank you, Judge. Have a good day.
Thank you.
Okay. What I'm going to do, counsel, thank you. I will cancel the warrant on the case that we're arraigning on.
I'm hoping
cancel the
a
warrant.
new random SovCit shows up.
Thank
That was
you.
fun.
And then
That
what I'll
happened
do,
about
I'll
15
just
minutes
set
into
his
this
bond
stream,
at a
but it was over
$5,000
way too
personal
fast.
cognizance.
Thank you, Judge.
All right. Thank you.
Yes, thanks.
Let's see here. We have about 3 minutes
Court does
left
call the case
on
of the
this
People's State
stream,
of Michigan
but I have Judge
versus
McBurney lined up.
I rely Schillis.
His
Ashley Lonnie for the people.
Afternoon, Judge Larry Margolis on behalf of Aurelie Peraza. How are you
one of
today?
his criminal
I'm doing well.
State your name.
Good afternoon, Your Honor. My name's Aurelie Peraza.
Thank you. All right. What are we doing?
We signed a waiver. I've gone over it with Aurelie, and we're prepared to move forward and waive to circuit court.
Oh, I do see it. Okay. Is that correct, ma'am, that you're waiving your right to a preliminary examination?
Yes, sir.
You understand that a preliminary examination is a proceeding where the people have to show by probable cause that the offenses alleged were committed and that you committed them.
Yes, sir.
You understand you'll not have that hearing and that you'll proceed to circuit court for further resolution.
Yes, sir.
People also waive their right.
Yes, Your Honor.
For you who are new here, let me introduce you to Mr. Jingles. He is the actual owner of this channel, and so I'm just the face of the channel, while Mr. Jingles here is making me do all this, so he can get all the snacks and all the toys and all the things. So if you become a member, I will make sure that Mr. Jingles will get treats and toys continuously.
Preliminary examination having been waived, defendant is bound over to circuit court on all 3 counts. As to the arraignment,
We'd waive a formal reading, Your Honor, enter a plea of not guilty.
defendant having waived formal reading, pleading not guilty, court will enter a not guilty plea as to all 3 counts. Pretrial will be set for
August 4th at 1:30. Oh, August 5th at 1:30 with a couple.
August 5th, 2025, 1:30 before Judge Gunke.
Thank you, Judge.
Thank you, Judge.
Bond will continue. Thank you.
I'm gonna go down now, Judge. I have a couple others at 3 o'clock, so I'm gonna get on my horse and see you in a minute.
All right. Thank you.
Bye.
Court calls the case People versus Aiden Coletta.
Good afternoon, Your Honor. Fabiola Calgar on behalf of the defendant who is approaching. Please state your name for the record.
Aiden Coletta.
All right. What are we doing?
Your Honor, at this time, I was able to touch base with Ali, with the prosecutor. Discovery has.
Ali?
Yes.
Who's that?
Miss Zenda.
It's okay. No, it's okay. Everybody just knows there's Allie anyway. Go ahead.
So I touched base with Ms. Zenda. Discovery has been complete at this time. I believe we're ready to prelim date.
People have their witnesses available the 24th?
We'll do our best, Your Honor.
All right. Preliminary
Hi,
examination
Tammy.
will be
I'm
set
doing
in
good.
person, June 24th, 2025, 9 a.m. That's before Judge Washington.
Thank you, Your Honor.
Thank you. Bond will continue.
Thank you, Your Honor.
Thank you.
Oh, but we have, let's see.
Do you all know? Whoops.
Here is Judge McBurney's court.
Who is at Macon State Prison? What position is that? Number 3. There it is. Let's start with that one because everyone's been waiting. And again, I apologize for that, but our good friends from GDC have made Mr. Williams available virtually. So I'd like to handle that first. Let's get him on the screen. Hey, Mr. Williams, can you hear us? Yeah. Good. Ms. Wood, I think I heard your quiet voice in the background, not in person.
Good afternoon, Judge. That's correct. I am appearing virtually. If I may have a breakout session with Mr. Williams, he will be mine.
Great. Mr. Williams, I'm going to do this digitally. You don't have to go anywhere, but I'm going to move you and Ms. Wood into a private space where the two of you can speak and no one else can hear what's going on. She just wants to talk to you a little bit about your case, okay? Great. Thumbs up. Let me see if I can make this happen. You are Macon State Prison and Lacey Wood. All right, see if it works. Looks like it. Excellent. So we have a plea and arraignment calendar and a revocation of an 03 case. Ooh, Carl Greenberg on it. Okay. Position 1. Whoops, let me get my handy dandy email.
Oh.
That.
Okay, so now we just want to listen to him for a few minutes before the video feed is back. Or?
Ms. Davis, it sounds like you are going to be making some announcements on behalf of Ms. Clark.
Yes, Judge.
You look surprised by that. She sent an email and copied you on it.
I will be ready to make those.
Okay. I mean, it has the announcement, so I know what they're going to be, but we'll let you make them. Okay. Mr. Nunez Ortiz is here. Good afternoon, sir. You've got 3 cases with us, but I think the lawyer who's going to represent you is in that breakout room. You had Mr. Lee as your lawyer on one of the cases, but he has filed a motion to withdraw. Is that news to you?
I don't know nothing about it.
You don't know nothing about what?
About I got a lawyer.
Do you think you have a lawyer or you don't think you have a lawyer?
I got a lawyer as far as I know.
Okay, well, that'll make it simpler. If you were here thinking that Mr. Lee was your lawyer, he's saying, no, I'm not your lawyer. But that you're okay with Mr. Lee not being your lawyer, it sounds like. Yeah, okay. Let me look at, I didn't notice the date. One of your cases is real old. 2 of them are brand new. But this super old one from 2017, Mr. Lee, Jerome Lee is his name. I get this up here. Entry of appearance in June of 2017. Nope, that's when you had the public defender. Here we go. In September of 2017, Mr. Lee filed an entry on your behalf, meaning you or someone in your family had paid him some money way back in 2017. I think that money is running out because Mr. Lee is saying he's going to come off the case.
Folks, video will be back as you see here. We are just going to listen to him. Hi, Tammy. Hi, Stringable. Good to have you here. Hi, Maggie, Ghost, Amica fan, Dave, and Reformed Convict. I see Gwendolyn. Good to have you here. Good to have you here. And Squeege of Justice. And who else is here? Who else is here? Who else is here? Well, it's my regulars. Thank you for being here. And then a bunch who came over here from Trial TV Live or Live Trial TV. Thank you for that. Remember, hit the thumbs up, subscribe if you haven't, and if you like my content, keep watching.
an attorney will be appointed to represent you, assuming you need a lawyer. If you're planning on hiring one, I'm not going to force a lawyer on you. Were you going to hire a lawyer, or do you need a lawyer? Well, pretend it's bad. Do you need a lawyer, or were you going to hire? If you have $1 million, it doesn't matter how bad your case is. You have to pay for your own lawyer. Okay. Are you employed? Yeah. Okay. Ms. Rios, I'm going to ask you when we get through calling the calendar to chat real briefly with Mr. Nunez-Ortiz. If he doesn't qualify for your office's representation, in other words, if he makes enough money, then I'll just reset your case one cycle so you can hire a lawyer. But before you leave, I'm going to let you know what all your cases are so you are less surprised, okay? So sit tight. Ms. Rios is going to chat with you in a little bit, and we'll go from there. Okie dokie. Mark Morris. Hey, Mr. Morris. Ms. Rios, is this your case or?
This would be Ms. Wood's case.
Okay, Mr. Morris, we got to sit tight while Ms. Wood, who was on that screen, finishes talking with the gentleman who's in state prison. And then she'll be ready to make an announcement on your behalf. All right, Malik Williams is on the screen. Martavius Kemp. Going once. Do you know, Ms. Rios, if that defense attorney name is someone from your office? Okay. All right. Ms. Davis, assuming Mr. Kemp doesn't make it in the next few minutes, bench warrant?
Yes, Your Honor.
All right. It's not a real old arrest, so bench warrant it will be. Position 5, it looks like Ms. Wood filed a waiver and Michaela Green was excused. Ms. Green, are you here? Okay, you didn't need to be. So that's a waiver and scheduling order. Position 6, Daryl Jackson. Hello, Mr. Jackson. I'm all right. Is this your case, Ms. Rios?
I didn't speak with the mentor this morning, but we talked a little bit, so I will get that waiver in.
Okay. So, Mr. Jackson, it sounds like Ms. Rios is going to be waiving arraignment on your behalf, which just means that she's entering a plea of not guilty. I need to look up your case real quickly to make sure we've got good contact info for you. Did you get something in the mail telling you to be here? All right. I've got an address on Barrett Drive. Good. And then the other thing I want to check with you is your bond order. It's a funny looking one. So you are not supposed to have violent contact with Darian Jackson. He's right there. You're not having violent contact with him, so that's all good. So just maintain that condition. I didn't even make sure it wasn't a stay away because I noticed you here with a kid. I want to make sure you weren't sitting in court violating your bond, but you are not. Okay, I think we are all in a good space. This is probably not your case, Ms. Davis?
No, Judge, I believe this is Ms. Clark's case, and the announcement is that we will provide discovery to defense counsel once there is a schedule.
Great, that's a great announcement. So, Mr. Jackson, what's going to happen next is that the prosecutor, who is not here today, is in another courtroom, she's going to get discovery, which would be police reports, whatever the state thinks the evidence is in the case. She'll get it to Ms. Rios. Then Ms. Rios is going to want to meet with you to talk about the case. And you and Ms. Rios will chart a course forward. Either there'll be motions that I need to hear, a motion to suppress, something like that, or Ms. Rios will be engaging with the prosecutor to say, how can we work this out? What does a resolution look like? A dismissal, a plea, or is this one that's going to trial? But you and Ms. Rios need to talk about it before she moves forward in that way, okay? Ms. Rios, do you need Mr. Jackson to stick around?
Yes, just briefly.
Okay. Mr. Jackson, I'm going to get through calling the calendar. Please don't leave until Ms. Rios has a chance to chat with you. Otherwise, you're good to go, okay? So you'll get that waiver filed in the next day-ish.
And we have video. Hey, thank you, Stringer Bell. Thank you for your
Scotty Lucas.
Thank you for your $5 super chat, which sadly on Rumble Studios I cannot post. But thank you so much. Thank you so much. His Stringer Bell is saying it's almost Friday. Let's get Nick to spin. Well, okay. Fridays, I usually have the Wheel of Regrets in the background, just in case people are feeling very, very generous. The Wheel of Regrets. I have no idea. Well, it looks like this. Hold on. I'll show you. I hope I can show you. It looks like this. So it has hot sauce. It has different kinds of alcohol. And usually, every $50 in super chats, gifted memberships, and stuff like that, I would spin the wheel. So it's pure entertainment. And probably tomorrow, if Prosecutor Love gets her shit together and have her witnesses lined up, we will do this while watching the new RICO trial out of Fulton County against Cash Out, who is charged with, how do I say this without getting demonetized? More or less running a brothel and grape and stuff. I have videos out on it because, as it seems, in the opening statement from the Beard of Justice, who is Mr. Cash Out's defense attorney, her SA kit tested against Cash Out's DNA, and it wasn't a match. How about that? So it is a new Foster clock out of Fulton County. And it's a RICO trial. And you know me, and RICO trials, I just finished one with the YSL, and I'm jumping headfirst into a new one. And now, Dave, thank you for $20. That is generous. Sing soon, the drunken Swede you are. Thank you so much. All right. Well, I will not spin today because I have work tomorrow, but I will count this into the tomorrow's first spin, which we are now at, like, where are we? We are at $30. So we are $20 from the first spin of the wheel tomorrow. All right, let's get back to Judge McBurney.
Was excused. His lawyer filed a waiver. Mr. Davis did, and that's it. So we'll get a scheduling order out, and I guess Ms. Davis is on both sides. You will get discovery to Mr. Davis. All right. Whoa! This person was here yesterday. Nevada. No, this person wasn't here yesterday. I had to enter an order yesterday. They did file an order. Okay. Nevada Twitchell. Is that going to be your case? Yeah. So here's my wires are getting crossed. Mr. Apt had asked if he and his client could be excused because he had filed a waiver. And what he really did was file one of these 400-page omnibus, whatever. And I struck that from the record, said if you file a waiver as a standalone waiver, then you and your client can be excused. And he did in the last sort of 24-ish hours. So Mr. Twitchell is not here. Mr. Apt is not here with my permission. And so we'll get a scheduling order out. You'll just need to get discovery to Mr. Apt. Great. I looked at this. Someone gave Mr. Twitchell a bond, so I'm assuming that's sort of where we are. And we'll go from there. Anything else on your behalf? Okay.
I believe that's my only excuse.
You may. Kendrick Brightwell. Hello, Mr. Brightwell. Ms. Rios, your case?
Yes, Your Honor. I just closed the gate. I will get that waiver in the system soon.
Okay. Mr. Brightwell, you have a warrant? Yes. Yeah, you can. I mean, you should talk with Ms. Why don't you talk with Ms. Rios? And then we'll talk. I'm not saying we won't talk, but we verified that it looks like it's an active, valid warrant. I will talk. I promise. You should talk with Ms. Rios first, but we need to work through that. So don't run out of the courtroom, okay? Okay. Talk with Ms. Rios. We'll have a conversation. Ms. Rios, regardless of how that conversation goes, you're going to do a waiver, and I'll do a scheduling order. Okay. All right. Anthony Brown.
I sent an email about him.
You did? Okay. Oh, yes, this one. Okay. Tell me, Ms. Davis, what steps you need to take in connection with Ms. Rios's email.
Yes, I just need to obtain an official death certificate.
Okay.
And from there, I will file and submit to the court and no cross-border.
All right. So that we don't lose track of this, should I put this on like 30-day inquiry calendar so that we'll be checking in then?
That's fine.
Is that, I want to give you enough time.
I'm not sure about my investigator would have to be involved because I asked the family for a death certificate, they said they didn't have it. So we obtained one.
Okay. I don't know how that works. It looks like Mr. Brown passed on February 4th, so it's been a few months. But it maybe was in another state.
Yeah.
So that complicates it. Let's set it 30 days-ish out. No one's in trouble if we can't get it then. I understand the state wants confirmation. Given these charges, that would be a pretty elaborate hoax to engage in to get around those charges, but I respect the state's desire to close out the file with a certificate like that. So we'll reset that. And if I can help in any way, if they need an order to get it done, let me know. Denitra Dawson? Ms. Rios, is this your case?
I believe so, but I've not had contact with her.
All right, let's make sure she is not online.
Judge, the attorney just filed a waiver in entry, Ricky Richardson.
Okay, I could have sworn Ricky Richardson he was getting out of the practice of criminal law. This must be a special case for him. But did he ask you if Ms. Dawson could not be here?
I'm not sure.
Okay. So let's start the bench warrant process, but I'm happy to hold on to it a little bit. If Mr. Richardson can get Ms. Dawson to appear virtually, that'll work. But this is one with an alleged victim, et cetera. So I'd need Ms. Dawson to make an appearance of some sort, unless you and Mr. Richardson had a conversation, Ms. Nelson. I'm not trying to countermand that at all. I just didn't have that listed in the email you sent me. All right, Ricky Richardson.
Thank you, Stringer Bell, for your $10 super chat. Says, I can't attend tomorrow, but you jokers have fun. Which gets us
Aaron Michael
only $10
Pendleton.
on the first spin on the wheel of regret
Tim Cook for
tomorrow.
Mr. Pendleton. We are both on Zoom separately. We did file our motions and a waiver, but are appearing and entering a not guilty plea and waiving arraignment today.
Excellent. Let me pull the case up. Sounds like you've covered all the spaces. Ms. Winfrey is in trial right now. So who is playing the role? Ms. Winfrey.
Playing Ms. Winfrey.
Okay.
As you said, she is in trial, but her staff will provide discovery to Attorney Cook once there is an order.
All right. It does look like the waiver was filed on the 6th.
Hi, Leslie. Good to have you here.
I think I saw it was like the last thing entered in.
Yep, it's there. You filed a bunch of motions. One of them says motion to suppress. I'm pulling it up now. Yeah, that's what I got. So
it's a general, Judge. It's not an omnibus, but it's a general.
Yeah, so don't file any more of those because my staff sees that and says, all right, we got to put this down, schedule it for a suppression hearing. And we really don't, because all you said is maybe the state messed up, and if they did, I want to suppress it. But you don't have discovery yet. So my scheduling order will have a deadline for the production of discovery and then a motions deadline that is after that. So once you receive discovery, then what I'd ask you to do is file, if you decide there is nothing that you want to seek to suppress, would be to file a withdrawal of those other motions. Because if we look back at this docket in 10 months, there'll be this motion to suppress that was never resolved, and that's problematic.
Understood, Judge. I will do so.
All right. Couple other things.
Oh, I just got the news. The Turtle Ball trial. The verdict is in. Not guilty of witness intimidation and all that crap. Now, folks, I'm not a big fan of how Turtle Boy, Aidan Kearney, conducts himself. I really am not. But freedom of speech, baby. We have to accept that there are assholes out there reporting on things. Because one person's asshole is another person's, hey, I like this. Just because I don't like how he conducts himself does not mean I have the right to suppress his free speech, which is what is going on in Massachusetts against Aidan Kearney. So yay for Turtle Boy, yay for Turtle Boy. Folks, you have a gift. You have a gift that is the freedom of speech, the First Amendment. Your founding fathers really knew what they were doing. Your early politicians in your nation really knew what they were doing when they did the amendments. Nowhere else on this planet do people have the rights you have of free speech. Nowhere else. You are unique in your freedom of speech. I wish we had what you have. Now, we have freedom of speech, sort of, unless the politicians really doesn't like it. You have free speech even though they don't like it, because what you have is unique and you need to protect it at all costs, because once it's gone, it's never coming back. If the people who are trying to suppress your free speech wins, you will not get it back. And so it's easy to be for freedom of speech if it's speech you like. That's easy. You have to protect it for the people whose speech you don't like. Why? Because it's hard, it's important, and as I said, once it's gone, it's never coming back. Then you are on a slope, a slipping slope, and all of a sudden you are like in Great Britain, where people get arrested for stuff they say. Or in France, if you not defame, but if you call the French Prime Minister a wanker, you can get arrested, because it's illegal to use profanity and stuff against the French president. And in other countries, it's even worse. Protect your free speech, folks. Protect it at all cost. All right, rant over. Let's go back to Judge McBurney.
Mr. Pendleton, I have an address of Windgate Lane in Lithonia. Is that a good address for you?
Yes, sir.
Okay. And your bond. Okay. In theory, you are on a curfew. Is that your understanding?
Yes, sir.
Okay. All right. Mr. Cook, as this case moves along, if for whatever reason you think it makes sense to revisit some of the bond conditions that have now been in place for a long time, over a year, I'm happy to do that. The to have that discussion. It may be that they remain appropriate bond conditions, but after a few months, oftentimes it makes less sense to have some of those restrictions in place. So if we need to have that discussion, let me know.
Thank you, Judge.
Davis, anything else on behalf of the state?
No, Your Honor.
All right. Mr. Cook, anything else?
Nothing more on behalf of the defense, Judge.
Okay. Well, discovery will be heading your way hopefully soon. How does that work, Ms. Davis? Ms. Winfrey's going to be in trial for a long time. Will her support staff be able to get discovery out? We're not hostage to the trial?
Correct. Her
Okay.
staff will be sitting up with her.
Okay, good. All right. Mr. Pendleton, any questions?
No, sir.
Okay, you two are excused.
Thank you very much. Have a good day.
You bet. All right, John Perrin. John Perrin is here. Excellent. Okay. Ms. Rios, you've already filed a waiver. Anything else we need to do in connection with Mr. Perrin?
Yes, he has an ankle monitor. I just wanted to address that. I know with very late notice, I did file a motion to remove his ankle monitor.
What would very late notice be? Today. Okay. Well, let's do a couple things here. First, Mr. Perrin, you're living on Riverdale Road in College Park? Okay. One thing we need to do today is do a change of address form, which is up here. Ms. Rios will help you fill that out, but we need to make sure that the right address is in the system for you. Did you get something in a...
You guys.
Oh, look at that. It just hasn't made it into the system yet. Okay. Looks like on the 4th, Baker's Fair Trail.
Yeah.
Okay. All the way out in Augusta.
Yeah.
Okay, great. We need to make sure that that gets into that change of address has been filed. It's not reflecting in the system. And your bond. I'm not seeing ankle monitor on the bond.
I have.
I did see it on, I did look at the.
Oh, here it is. It's in a weird spot and it's okay. Got it. So you've had one since February. We're only on month 4 of the ankle monitor.
Saying that it was.
But it's creating sores on my foot and I'm diabetic.
Okay. So there's some health concerns you've got by having it on.
Yeah.
Okay. All right. Demetrius Perrin is related to you in what way? Okay. You've been staying away from her while you've been on bond?
Yeah, I've been living in a bus.
Okay. Here's my thought about that. I'm going to ask, will this end up being your case, Ms. Dilligard? I'm going to ask Ms. Dilligard to reach out to Demetrius Perrin. And you don't have to do that right this moment, but in the next day or so. And then you can just via email to me and Ms. Rios and Ms. Nelson say, look, I spoke with Demetrius Perrin and she don't have a concern about ankle monitor. And then I'd like to get your thoughts on it as well. You may say, given the health issues it's causing Mr. Perrin, we don't object. You may say it's only been 4 months and we do object. But I just want to hear both sides. I'm just not holding you responsible for not having connected with Ms. Perrin, given that the request to modify was filed how many minutes ago? Earlier today.
Yes, Judge, and I spoke with Ms. Perrin, not on the issue of the ankle monitor. I did speak, or my advocates have spoken with her yesterday. So I will run it by her.
Okay.
This afternoon. I have a question for the court for counsel. Is it like it needs to be adjusted? Like is it adjusted? That's why he has sores, or? I think the ankle monitor having on self is causing the sores with his.
Mr. Perrin, I don't want you to get graphic with us, but is it your sense that a different ankle monitor or a less tight ankle monitor would not create the sores, or something about diabetes and your ankle, the monitor is just going to rub in a way where it creates these health concerns?
My diabetes ankle monitor is just going to rub it and it's going to create sores.
Okay.
It may cost me my foot.
Well, that's not what anyone wants to have happen. So it's not this particular device. You think anything down there, you wouldn't put an anklet on or something, no jewelry down there.
No.
Okay. All right. That's helpful to know. So Ms. Dilligard, if you could in the next few days, you or someone on your team reach out to Ms. Perrin and then circle back with Ms. Rios and me. We don't need to get Mr. Perrin back in here if I'm going to modify it. Just enter an order and we'll handle it that way. And that's it. Ms. Rios, anything else on behalf of Mr. Perrin? Mr. Perrin, do you have any questions about anything we discussed? No. Okay, Ms. Rios will be in touch as soon as she gets discovery in this case. She's going to want to talk to you about it so that you and she can discuss where the case is going. And she'll certainly let you know what I decide about the ankle monitor. How did you get from Augusta to here? A friend? Yeah. Would that friend be able to get you back here next week if I say the ankle monitor can come off? Because you'd have to come back here for that to come off. Yeah. Okay. All right. Thank you. If there's nothing else, Ms. Rios, do you need Mr. Perrin to stick around? All right, Mr. Perrin, you're good to go.
Thank you. Enjoy your day, Judge.
You too. Ms. Wood, I see that you are back. Oh, and then the remainder of the calendar, Mr. Nunez Ortiz's other two cases.
Yeah, this is what I like about Judge McBurney. He, in my opinion, is fair. He actually tries to help people. Even when he has a sovereign citizen in front of him, he never loses his cool. Never. I've never heard him shout at somebody. I haven't. And I watched, hundreds of hours of Judge McBurney. Now, do I agree with him all the time? No. But I do think he strives to being as fair as possible.
We made it through the calendar. You and Mr. Williams had a chance to talk?
Yes, Judge, and we're going to try a plea today.
Okay. Before we do that, I want to touch base on a couple things, and then we'll jump into that. Mr. Nunez Ortiz is here. He had Jerome Lee on a case 8 years ago. Mr. Lee has rolled off the case, and I think Ms. Nelson's notes say that you will handle Mr. Nunez Ortiz's 3 cases.
That's correct, Judge, and I believe my team has given him my contact number, and I'll just get waivers filed today.
Okay. Did you, Mr. Nunez Ortiz, get information about Ms. Wood?
In his paper, but I don't know who it is.
Well, I'm not asking you, but does it have Ms. Wood's name on it and a phone number?
Yeah.
Okay. So who it is that person on the screen. Okay. That's Ms. Wood. She's the senior public defender in this courtroom, and she's going to be your lawyer. Did you all talk with Mr. Nunez Ortiz about his financial wherewithal? Okay. So temporarily, at least, Ms. Wood's going to be your lawyer. When she's done with court, she'll call you. You can call her. And probably the first thing you guys will talk about is your finances. Because if you earn too much, then you don't qualify for public representation and you'll need to hire a lawyer. Even if you don't earn too much, if you want to hire a lawyer, your uncle is a millionaire or something, you can always hire your own lawyer. What I don't want you to do is be floating through the system with no lawyer. That's not a good plan for you. So Ms. Wood is going to represent you for now. You should chat with her when you both have an opportunity, and then we'll figure out how to move your cases forward, okay? But if in the end of that first conversation she says, I'm sorry, I can't represent you, she will let me know that, and we'll get a new date for you to come back here where you can say, great, here's the lawyer I've hired, and I'll give you some time to do that, but you will need to hire a lawyer. Let me make sure we've got a good address for you. I don't want you to not be here next time.
Yeah, you really need an attorney in front of Judge McBurney because...
Well, you have, looks like one of these cases will be yours, Ms. Dilligard.
This is Fulton County. This is in the same county where Prosecutor Love hangs around. So these prosecutors are employees of Fannie Willis. I don't trust them at all. So please get if you're in Fulton County and something happens and you are in front of a judge, get yourself an attorney, a good one, the best you can afford. Because my standard when it comes to Fulton County is that the prosecution will cheat every time.
At least one, maybe the false imprisonment also? Yeah. Not the arson from 8 years ago. So I have 2 different addresses for you, Mr. Nunez Ortiz. There's a Hemingway Lane and a Cedar Trace.
Cedar Trace is the right address.
Cedar Trace?
Yeah.
Did you get something in the mail telling you to be here today?
No.
How did you make it here?
Oh, because my ex-wife sent the papers with that.
Your ex-wife. So something got sent to her. Does she still live at Hemingway Lane? Okay, so that's where it's going. We need it to be the Cedar Trace address, 120. Is there an apartment number? Okay, 120 Cedar Trace. That'll get to you. Okay. All right. And did you get contact information from Mr. Nunez Ortiz? Okay, before you leave, please provide this young lady with a way to reach you so that Ms. Wood can call you if you're being shy and not calling her. All right? Once you give her that info, you're free to go. All right. So Ms. Wood, you will file a waiver of arraignment in the 3 cases to at least advance this along?
Yes, Judge.
Okay. All right. Thank you. Then why don't we handle Mr. Williams' situation? Do you need to talk to Ms. Davis, or have you been emailing her?
No, Judge, but this is, we'll do it non-negotiated, but he's been in custody for 2 years, so it should be relatively simple.
Okay. Ms. Davis, you ready?
I just want to have a couple minutes. I just want to check something in the system.
Okay.
For the victim.
Got it.
All right, now let's see, because we have seen on my channel Judge Whitaker do a bunch of these pleas that is not negotiated with the prosecution. So it will be interesting to see how, this will be interesting.
We're giving Ms. Davis just a moment to get organized on this one. Ms. Wood, did you have any other, I think we covered most everything. Did you have a client? There's Mark Morris.
Did he show up, Judge?
He's here. Yeah, he's in the back of the courtroom.
Okay, I think Ms. Turlip was going to speak as well.
Hold on one second. Let me mute Macon State for right now. Say that again.
I think Ms. Turlip, Kaylee, was going to speak with him as well and just exchange contact. I will get a waiver in for him as well.
Okay. Mr. Morris, did the young lady who's talking to Mr. Nunez Ortiz already talk to you? No? Okay. Oh, I'm glad you already had it. She's going to want to get contact info. Do you have Mr. Morris's contact information, Ms. Wood?
Judge, I have 4 different phone numbers for him, but none of them connected with him. So if he can just give that to someone, that'd be great.
Okay. You play hard to get with your phone? Okay. Well, when you get arrested, you give a phone number that goes in the system. Okay. Well, let me look you up here. Yeah, I got 4 numbers in the system here. It's got you living on Lavender Drive, and then a number that ends in 6898, one that ends in 6713, 6713, that's a good one. One that ends in 9386. Oh, there's a typo. What's the area code for that one? 404. It says 405 here. Yeah, they typed it wrong. And also not 5106. Okay, but the 6713? 966? Okay. All right. I'll get that to Ms. Wood.
Thank you, Judge.
You bet.
Judge, just a heads up, Daryl Jackson, just let you know, I was confused about our qualification for people to qualify. I don't believe it qualifies. I didn't realize retirement is still major income.
Mr. Jackson, is he the...
He's number 6.
Oh, who was hugging the victim in the case? Okay. You think you can't represent him, meaning your office is disqualified? Yes. Okay, so.
I'm gonna text him to let him know that he needs to fire.
Okay, we'll reset this about a month out for attorney appearance. All right. While I'm working with Ms. Wood, will you please talk with Mr. Brightwell about his warrant?
Yes.
Thank you. Oh, they haven't? Oh, yeah, I had it sent to me even. Okay. Well, we'll hold off.
It's been about an hour. I just checked in again.
Okay.
Judge, I sent you an email regarding that. Did you get it?
I did. I haven't read it yet, but I'm gonna pull it up in just a second.
All right, I see that StreamYard is up again.
But to close the loop on Mr. Morris, Ms. Wood, you're gonna waive arraignment on his behalf.
Yes, Judge, I will get that filed after court.
Okay. Let me do one more thing. So Ms. Dilligard, is position 2 your case?
Mark Morris?
Yes.
Yes.
So Mr. Morris has no bond. He had an $80,000 bond that was issued in 2023, but his case was dismissed. And so that bond isn't a bond anymore. I don't think he ever, did you ever make bond, or did you get out, Mr. Morris, because your charges were dismissed? Yeah. So he it's not that he's on no bond status. There's no, this has come up before where it's a direct indictment. And right. So I was looking up the bond to just make sure that the young lady sitting next to him wasn't the subject of the bond, because he was supposed to have no contact with Shannon Jones, but that bond is not his bond. So FYI, there's no bond in the case. Mr. Morris, you are free to go. Stay in touch with Ms. Wood, okay? Just so I know, are you Ms. Jones? No? Okay.
So the system now.
Hi, Shanagram.
I got an email about it. Let me look at the email.
Yeah, they can't verify the GCIC down. So
the,
GCIC down,
Rumble.
we can't take them in unless they got a.
I understand.
Rumble Studio.
It's an APD warrant. Says on APD side. Yeah, we can't. Got that warrant on hand. Nothing confirming.
Yeah, and someone named Altovice Gardner from your office is saying,
That's the GCIC, that's the supervisor.
yeah, she said, like, I can only verify them if your office receives them. It's just an issued status. So it looks like we will not do anything with it today.
Yep, can't confirm it.
So is Rachel able to be there?
What do you mean? If pretrial issues a warrant,
No, they pull from the same system.
GCIC?
oh, like, couldn't they do their job today? I don't know. Let's find out.
What's the question?
It's not a question for you. Hey, pretrial, how are you doing today?
I'm good. How are you?
I'm all right. Are you able to run GCICs right now, Ms. Roberts?
No, GCIC is down for me as well.
All right. So
But I
there's.
did, I couldn't tell you I ran his history.
Say that again?
I ran his history on Thursday. The warrant did come back, but that was on the 5th when I ran history.
Oh, what does it mean the warrant came back? That it was a valid warrant?
Well, it came back on the GCIC as a valid warrant.
Oh,
You still need that. APD still needs to confirm the warrant.
got it. So,
That's the issue.
and they are not calling back, or, okay. So GCIC tells us it's active, but then we confirm it only with APD or any, if it was from Ostel, we can.
APD's warrant. APD has to confirm.
Okay.
What happens is our GCIC will contact Atlanta police
Got
and
it.
say, hey, we got a guy, he's in courtroom 8F, says he has an active warrant. Out of you guys.
Yep.
You guys want to hold, I'll definitely take him in. Can you confirm the warrant?
Got it. Because they could say, we're not going to come pick them up, in which case then we're not going to serve the warrant.
Correct.
So even though GCIC is down, in theory, APD could call back saying, oh yeah, he is on our top 10 most wanted list. You better honor the warrant. But we're not hearing from APD. Okay. All right.
Because you never want to do anything verbal, Judge, but that same officer, yeah, we're going to get him. Then 2 days later, oh man, I didn't tell y'all that.
Yeah.
It is.
All right. Lots of moving parts today.
Can you please get to the non-negotiated plea deal? I want to hear this.
All right. I think all that's left, we have the revocation still, but is Mr. Williams's, this bond, this warrant, what are you hearing about Mr. Brightwell's warrant?
He thought he was okay. He's not sure he has an idea of what it could. There was an issue with the mother and child, but they told him he was fine when there was an altercation. So he didn't think the only thing he could be is something with that. So it would be that he could be, but he thought everything was okay.
Okay. Who told him things were okay? Meaning the police did, or?
He called me. Said she wanted to put the police on me. I told him my whole situation.
They said this is on fine. As I'm leaving the police precinct, before I even get out of the police precinct, my sister called me on the phone, said the police have lived for me. So immediately I go back in the police precinct, they tell me, she called the police officer from my phone person. And tell her the whole situation that I just explained to her, I promise you that I just explained to her. She called the police officer for a personal phone and tell her the situation, basically, that my baby mom like an aggressor, that she just popped up and this causing problems. All the things we did, put her in this automation, make her leave. The DPS got the situation with this kid outside.
Okay. How long ago was that?
A month ago, she just contacted me. I just put my son game yesterday. I didn't know nothing about this. I didn't know nothing wrong with that.
Okay. Your address is on Thomasville Estates? No? All right, Ms. Rios, we need a good address for Mr. Brightwell. Akira Willis, who's that? That's your cousin? Okay, that's not your baby's mom.
Yes, that's not me.
Okay. All right. If we get a good address for Mr. Brightwell, he should go before we can confirm the APD warrant. You and he may want to follow up on that because it's showing in the system as active. We just haven't been able to get word from APD as to whether they want it to be executed. And I won't keep Mr. Brightwell here any longer. All right, Ms. Wood, you ready to go? Oh, Ms. Davis, are you ready to go on Malik Williams? It's been a couple minutes now.
It has been.
All right, so come on up here. Let's get Mr. Williams on the screen. Boom. This. Ms. Roberts, are you going to have criminal history information on Mr. Williams, or because GCIC is down, or did you run it a while ago?
Yes, I have. I ran it last week.
Huh. Do you usually run it in advance, or this was just good luck for you that you ran it before GCIC crashed?
If I have it, I'll run it in advance. And GCIC is back up too, by the way.
Oh, okay. Thank you.
You're welcome.
Hey, Deputy Gordon, GCIC is back up, but that's not going to help us here because, again, it's APD we're waiting on. Do they usually take this long? Okay. Well, he's gone now anyway. Won't make you run after him. Deputy Gordon needs oxygen. All right, Ms. Davis, are you ready?
Yes, Your Honor.
Okay. Ms. Rivers, are you ready?
Yes, I am. Good afternoon.
Good afternoon. Mr. Williams, I'm going to have you unmute now. If you can do that, or if someone in there can press the button so that the system is not muted. Perfect. You did it. All right. Can you hear us?
Yes, sir.
Okay. So Ms. Davis, who is on the screen there at the bottom, is the prosecutor on your case. She is going to swear you in just a moment and then ask you a bunch of questions about your rights. You need to answer those questions truthfully and completely. Ms. Wood is listening in and will be involved throughout. If you have any questions at any point, let me know. And if I need to put you back in that private virtual conference room with Ms. Wood, we can do that. But it could be a question that I can answer. But I need you to do this or say, excuse me, if you either can no longer hear us or if you've got a question. Will you do that?
Yes, sir. Yes, sir.
Great. Okay. When you are, so we're clear on the record. This is 25 SC 002522, State versus Malik Williams. Mr. Williams is appearing from Macon State Prison. Thank you, GDC. Ms. Wood is appearing from her secret location. Ms. Davis is here in court with me. Mr. Williams, are you waiving your right to appear here in open court and telling me that you're okay appearing virtually?
Yes, sir. Yes, sir.
Okay. Are you waiving your right to have Ms. Wood at your side, knowing that you can speak with her privately if you need to?
She's still by my side, though, right?
She is. She's right there. She's feeling it and she's listening, but you can't actually just lean over and say, like, what's this judge saying?
Okay, I understand. I understand. Yes, sir.
Okay.
Yes, sir.
All right, good. Then we're going to go forward. Ms. Davis.
Can you please raise your right hand? Do you swear or affirm that the testimony you shall give in the matter before this court shall be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Okay, you can put your hand down. Please state your true and correct legal name.
Malik Williams, ma'am.
Can you spell your first name for the record?
Malik.
Are you at this time under the influence of any alcohol, drugs, or medication?
No, ma'am.
Is there any medication that you normally take that you have not been given today?
No, ma'am.
How old are you and how far have you gone in school?
14 years of schooling, and I am 48 years old, be 49 this year.
And where does 14 years of schooling put you?
A couple credits short of an associate's in science.
Okay.
Where'd you go to college?
DeKalb Perimeter College.
All right.
Are you able to read, write, and understand the English language?
Yes, ma'am.
Do you understand that you are charged with the following offense? It is a 1 count of robbery, and that is in 25 SC 002522.
Yes, ma'am.
Do you understand that you have the right to plead either guilty or not guilty to these charges? And if you plead not guilty or remain silent, you may receive a jury trial.
Yes, ma'am.
Have you had enough time to speak with your lawyer, Ms. Wood, about all the facts and circumstances known to you regarding this indictment and any potential defenses?
Yes, ma'am.
Do you need more time to discuss this case with your attorney?
No, ma'am.
Are you satisfied with her services?
Yes, ma'am.
Ms. Wood, do you waive formal reading of the indictment and any and all defects therein for the purposes of this plea?
So waived.
Mr. Williams, do you remember being arrested on these charges?
Yes, ma'am.
Your Honor, I'm unaware, the state is unaware of any outstanding warrants related to this case. Attorney Wood, are you aware of any outstanding warrants related to this case?
I am not.
Mr. Williams, has your attorney advised you of the minimum and maximum sentence for the charge to which you are pleading today?
Yes, ma'am.
And for a robbery, the maximum sentence would be 20 years.
Yes, ma'am.
Do you understand that if your guilty plea is a blind plea, also known as a non-negotiated plea, the state may still recommend a sentence to the court?
Yes, ma'am.
Do you understand that the court can impose any sentence authorized by law, including a higher sentence than recommended by the state, up to the maximum sentence on this charge?
Yes, ma'am.
Do you understand that this is a guilty plea, which is permanently recorded on your criminal history?
Yes, ma'am.
Do you understand that this plea may be used to enhance sentencing on other convictions in this jurisdiction as well as others, including federal courts?
Yes, ma'am.
Do you understand that if you are not a United States citizen, a guilty plea conviction will affect your immigration status and will result in deportation just like a conviction at trial would? And that is true regardless of any advice by your attorney or anyone else.
Yes, ma'am.
Do you understand that by pleading guilty to a felony, if you use, receive, possess?
Yeah, slight interruption. Folks, this guy has been incarcerated in jail for 2 years. I think that is absolutely abhorrent, whatever the word is. It's not fair. Because the longer you are in Rice Street or Fulton County Jail or whatever, the more probable it is that you will try to take a plea deal just to get out of the jail and into prison. Even though you might have a good case or you might have a bad case. You might want to fight it. But after 2 years in jail, well, this is Macon State Prison. So, yeah, I just generally do not like lengthy incarcerations of people who are supposedly innocent unless proven guilty in a court of law. In my opinion, if you cannot bring charges within 30 days, let them out. I don't care what the charges are. I really do not care. Because if you do not have the case when you are arresting, if you don't have everything starting to be lined up within 30 days, if you don't try to go for trial, then as a state actor, you're not doing your job. And the people should not suffer because the state does not do its job.
Possess or transport a firearm or use a firearm in a crime, you'll be guilty of a felony which may carry a sentence from 1 to 15 years in prison.
Yes, ma'am.
Do you understand there may be other adverse or unfavorable consequences as a result of this guilty plea conviction, just as there would be from a conviction following trial?
Yes, ma'am.
For example, your guilty plea may affect the right to vote, to hold public office, to serve on a jury, to obtain a passport, to receive, possess, or transport a firearm, or the ability to obtain employment.
Yes, ma'am.
Do you understand that you waive any and all defenses, including mental health defenses, by entering a guilty plea?
Yes, ma'am.
Do you understand that by pleading guilty, you're giving up the following rights: the right to a trial by jury,
Yes, ma'am.
the right to remain silent and not incriminate yourself,
Yes, ma'am.
the right to confront witnesses against you,
Yes, ma'am.
the right to the assistance of counsel hired by you or to court-appointed counsel if you cannot afford an attorney at a trial of your case,
Yes, ma'am.
the right to the presumption of innocence,
Yes, ma'am.
the right to testify on your own behalf and to present other evidence,
Yes, ma'am.
the right to subpoena witnesses and compel the production of evidence,
Yes, ma'am.
the right to have the charges against you proved beyond a reasonable doubt,
Yes, ma'am.
the right to appeal a conviction of these charges after a trial.
Yes, ma'am.
Do you understand that you may only have a limited right to appeal this guilty plea conviction?
Yes, ma'am.
Do you understand that you only have 4 years from today for this felony charge to file a habeas corpus petition challenging the voluntariness of this guilty plea?
Yes, ma'am.
How do you plead to the charge of robbery in indictment 25 SC 002522?
Plead guilty with under the circumstances.
Okay.
This will be an altered plea, Judge.
Okay.
Mr. Williams, has anyone forced, threatened, or promised you anything to get you to enter this plea?
No, ma'am.
Unless you count 2 years incarcerated.
Is it your decision to waive the right to enter this plea because you're in fact guilty or
Yes,
pleading
ma'am.
under? Okay. Is this freely and voluntarily given with the full knowledge of the charges against you?
I didn't understand. Repeat that.
Is this plea freely and voluntarily given with the full knowledge of the charges against
Yes,
you?
ma'am.
Okay.
Yes, ma'am.
Your Honor, we believe at trial, the state would prove that on March the 20th, 2023, at about 6 o'clock in the morning at 5335 Roswell Road in Atlanta, Georgia, in Fulton County. This location is a Waffle House that the defendant did enter the Waffle House and order a small coffee. The defendant pretended to be paying in cash. The victim in this case, Miss Yvonne Kotadia, last name Kotadia, opened the till drawer to accept the cash, and the defendant pushed her out of the way and snatched the till of the cash register.
Oh.
The defendant was able to take $298.88. Upon review of the surveillance footage at Waffle House, they observed a Buick Terraza with the Georgia Tech CCY 8985 that was parked in a way that it seemed like it was ready for somebody to basically pull away quickly from the scene, which that vehicle did. Upon investigation, officers were able to determine that the plate for that vehicle did not match the vehicle that was being driven, that the tag was also stolen. But officers were later encountered Mr. Williams driving this Buick Terraza bearing the same license plate. They also noticed that there was distinguishing features on the vehicle, that it was missing both rear passenger handles. Mr. Williams was arrested driving this vehicle. It appeared that he had on the same vest, a gray camouflage vest underneath a black jacket this time, but that was a vest that was worn during the Waffle House encounter. Upon review of Mr. Williams' history, it appears that Mr. Williams has 4 previous robberies that had reached conclusion. He has 9 misdemeanor convictions and 9 probation violations. So we do not believe that this circumstances or he would be a good candidate for a probated sentence. I believe the last sentence that Mr. Williams received was 15 years to serve, and we'd be asking the court to make that same sentence here in this case.
When you say the last sentence he received for whatever his last robbery conviction was? Okay, got it. Thank you. Ms. Roberts, it sounds like you were able to run the criminal history, the system is back up now, but a few days ago. Can you share what you have for Mr. Williams, please?
Yes, I show a total of 42 cycles. I also show 5 robbery convictions, 4 from 2012 and 1 from 2006. A criminal attempt to commit robbery conviction in 2006, and nothing further to add, Judge.
Okay, what's the most recent arrest you've got?
Most recent arrest is from April 11, 2023 for a parole violation.
Got it. Okay, thank you so much. Ms. Wood, talk to me a little bit about the Alford side of things, and then anything else you want to share about this case or Mr. Williams.
Thank you, Judge. So of course we are at arraignment, so I don't have full discovery. I went over that with Mr. Williams. I do have the arrest warrant It's noted in the arrest warrant that he told the officers when he got arrested that he basically didn't operate in Fulton County, so it could have been him. And honestly, that tracks because this is the only case that I see that matches his identifiers here in Fulton County, Judge. It looks like he's primarily based out of DeKalb County. Mr. Williams shared with me that there was someone else that had borrowed his vehicle at the time. And of course, since I don't have surveillance yet, I cannot compare that identifying surveillance with any photos of Mr. Williams, Judge. So the reason he wanted to go ahead and put this plea up today, non-negotiated and under offered, is because he has been in custody since his arrest in 2023. So he was booked into Fulton County Jail on April the 11th, 2023. He did 38 days in Rice Street, and then he went directly to the Department of Corrections. He is there until at least July the 27th of this year, Judge. And then he has asked me to ask the court to banish him from the state of Georgia. He has no reason to be here anymore. His elderly father lives in Maryland. His two daughters, ages 21 and 22, are both in Maryland. He has no desire or reason to be in this state in the future. And so he's asking the court to just essentially do a time served straight sentence. I don't know. I guess we would have to suspend something if we were going to order banishment.
Right.
But otherwise, that's what he's asking the court, Judge. He does have some college education. He's 48, as you heard. He was working for Amazon prior to his arrest, and he's been doing well with the Department of Corrections. He's on the laundry detail there. His plan, once he makes it back to Maryland, his father has an HVAC business. And so he is hoping that once he gets back to Maryland, he can sort of slide in there and take over for his father, who is now at a retirement.
Okay. Got it. Mr. Williams, what I'm hearing Ms. Wood say is that you don't think you did this one, but you don't remember, or you know you didn't do this one, or what? I appreciate that you generally operate in DeKalb, but it's not like Fulton County is all that far away from DeKalb. I mean, you take a wrong turn on Moreland and you are in Fulton rather than DeKalb.
Yeah. It's just that right now, it's like I was telling Ms. Woods, I'm 48 years old, and my whole entire life I've never heard my father cry before. And he asked me, he's like, "Can you get here within a year?" And and I've never heard him shed a tear or watched him cry ever in my life, And Ms. Woods, she just said that I could probably get everything handled, and when I leave here, I would try to get a bus ticket to go directly to my father. He has a HVAC business that he owns himself, and I guess he wants to show me the ropes and try to get things established because he has an illness right now where he's not going to be around for long. Parents don't tell you the extent of what's going on with him, but I know things are bad. And I've lost my mother and sister already, and I just want a chance to start over in Georgia. I've been locked into a probation period over and over and over and over in my life. I've never had a chance to get ahead or get that from over the top of my head. And just being able to leave Georgia and be with my father and some type of stability and everything, I'll be like, I've done a lot of time here, and I don't want all of my family to die without me seeing them. And I just want to get to my family, sir.
Okay. Well, I hear you. Nothing like family. You've also done a lot of crime here, which is probably why you've done a lot of time here. But if you can get back to your dad and help him out, I think that's an important thing. Ms. Simpson, what do you know about remaining parole or probation? Because this banishment from Georgia is an interesting concept, but if Mr. Williams has 10 more years of probation out of DeKalb County.
He was on parole. He paroled in January 23.
Because his sentence was all time to serve, yes, and he paroled.
Yes, straight constant.
Okay.
And the violation that got him brought back into custody was actually a technical violation. He moved and didn't notify his officer.
It wasn't this case?
No.
Okay. Are you able to tell how much parole he has? I don't know how that works.
The case was starting on expires in the date that this book gave is the date of the.
Oh, that's not just hey, they might want to let him out, but that's the end of the 15 years. Mr. Williams, how many of the 15 years did you serve before you paroled out?
Rated 13. Rated like 13 years. My whole time I was on parole was trying to establish to get my parole transferred to the state of Maryland because I had no family. And the parole officer kept telling me I have to do my parole here. So I would have had to do the rest of the parole, but I got sent back here because he said he was just going to have me locked up for a few months for the technical violation, which was not having a steady address. I have no family here. So he violated all of my parole because of this charge. So I ended up doing a little over 2 years because this charge was pending.
Okay. Got it. So come July, meaning next month, you're done with your decap sentence.
I won't have any ties to Atlanta, to Georgia. And, you know, my mom died here. My sister got killed here. It's nothing here. The only family I have is my father and my 2 daughters, and they're in Maryland.
Okay.
I've lost so much family while being. Yes, sir.
Okay. Got it.
What will
All right. Well,
we
Mr. Williams, I find there's a factual basis for your plea. I understand that you are pleading under North Carolina versus Alford, which is that you're saying this is in your best interest. You're not necessarily admitting all the things that the state said happened in this case. But if the state were able to prove what Ms. Davis shared with me, I think that's a sufficient factual basis. I also find that your plea is knowing and voluntary. Knowing means you've understood what we talked about, and voluntary means no one's forcing you to enter this plea. Do you agree that your plea is knowing and voluntary?
Yeah. Yes, sir.
Do you have questions about anything we've been discussing?
All right. I was just told that, you know, we would try to sort this out so I could get to my father as soon as possible.
Right. And where we are right now is if the sentence that I impose is more severe than what Ms. Wood asked for, you can back out of the plea. You can say, oh, nope, I'm gonna respectfully wait on this one, Judge. No, thank you. I want to have a trial in my case. So you're not locked into anything. And I haven't told you what I think the right sentence is yet. But once I do, you'll have a chance to reflect on that with Ms. Wood. We can put you in one of those breakout rooms. You guys can talk about it, and then you can let me know, I'm okay with this. Now, if I sentence you to what Ms. Wood asked for, you don't get to think about it. I'm giving you what you asked for. But if it's something more, and the state has asked for a whole lot more, then you'll get a chance to talk with Ms. Wood to decide whether you want to go forward or not. Okay?
I understand, sir.
All right. Did you have other questions? I didn't mean to cut you off.
I just want to apologize, sir. Everything happened so fast. I mean, just the dominoes fall, and it's like sometimes, you know, you can't stop dominoes from falling. That's all.
Once they get going, you're right. Ms. Davis, I didn't hear you say anything about restitution, but it sounds like by the time the police caught up with Mr. Williams, or at least the person driving that Buick with the missing handles on the doors, they didn't recover the $200 and something.
That is correct, Judge. I do, now that I have an opportunity to speak, want to add to the record that the investigation did also encompass analyzing Mr. Williams' cell phone, which they say pinged from the area near the Waffle House, as well as a tag pinged near that location on the date. So the cell phone, the stolen tag, and the visual identifiers are why they ended up arresting him for the robbery.
Okay. Well, the case is even stronger for the state, but Mr. Williams is entering a plea, so we're good there. But about restitution, are you seeking payment back for Waffle House, or it was $200 and Waffle House has 2,000 stores, or what?
I would be requesting the $298.88 restitution.
$298.88. Got it. Mr. Williams, what else do I need to cover? Ms. Wood, can someone in my office sign the indictment on your behalf?
Yes, Judge.
Ms. Davis, can someone sign on your behalf?
Yes, Your Honor.
And Mr. Williams, you're way down in Macon State Prison. I don't have an indictment to hand you there. Is it okay if we electronically sign your name to the indictment indicating your offered plea?
Yes, sir.
Okay. All right. Accepting your plea as an offered plea, Mr. Williams, I find that a reasonable sentence, given the passage of time and where you are in life, is a sentence of 10 years to serve 3 years, with the balance suspended, which means that when you are paroled or released, then you're not on probation. 2 special conditions of your suspended sentence. Number 1 is you don't violate the laws of any state in the United States or federal law. Number 2 is that you stay out of the state of Georgia, with the exception of the Eastern Judicial Circuit, which is Chatham County, which is basically Savannah. I'm actually not allowed to banish you from the whole state of Georgia. I have to give you at least one judicial circuit. Today, the winner is the Eastern Judicial Circuit. So if for whatever reason you want to come back to Georgia after you connect with your dad and your daughters, you can, but only the Eastern Judicial Circuit. That is real far away from Fulton County and DeKalb County. Okay?
Yes, sir.
All right. Do you have any questions? And I'm not ignoring the restitution, but I think a suspended sentence makes more sense than a probated sentence. And I can't really impose a restitution requirement. So I will pay the upcharge on eggs at Waffle House to cover that over the next 20 years. Mr. Williams, do you have any questions about the sentence that I imposed?
No, sir.
Now, the sentence that I imposed is a little more severe than what Ms. Wood asked for. It is less than what the state asked for, but more importantly, it's more severe than what Ms. Wood asked for. So I'm going to let the two of you talk in a breakout room. Ms. Wood can give you her advice about, well, this is what it would be like. You have to come back to Fulton, wait for trial, etc. But in the end, I'm going to need to hear from you about whether you want to go forward with this plea or if you would prefer to withdraw your plea, and then we'll get you up here when you're done with your time in the state system and move you forward towards trial. Okay?
Yes, sir.
All right. I'm going to put you back in that breakout room. And when you're done, you guys pop out just like you did.
Yes, sir.
Thank you, Judge.
Thank you. Let's see if I can make that work.
Okay. Let's see when they got back.
It worked. Excellent. All right. Ms. Rios, are you handling the revocation?
Yeah.
That's a perfect overlap. It is back. Whoops, wrong button. Let's do that.
All right.
Okay. And back in the witness stand is Ms. Davis. All right. Ms. Wood, did you and Mr. Williams have enough time to discuss his options?
Yes, Judge.
Okay. And what is it that Mr. Williams wants to do?
He's fine with the court sentence. He did just want me to ask to have it on record that he will get credit for the time that he's been with the Department of Corrections. I've done a quick check. I think he should, but he wants to hear from the court. I have some case law and statute, but I think he should be good with the credit dates.
So, Mr. Williams, let me say this about your request. That is my intention, but I'm not the boss of the Department of Corrections. And so I will put in the sentencing sheet that you are to get credit for all time that you've been in custody from that April date of arrest of whatever year that was, 2023. You went into custody in April of 23. The Department of Corrections may digest that differently than you and I expect them to, but that's where Ms. Wood jumps into action with the case law that she mentioned. And she can get involved, I can get involved, but my intention is for that number of years that I described to include all the time that you've been in. Okay?
Yes, sir. Yes, sir.
All right. Do you have any other questions about anything we discussed?
No, sir.
Okay. Ms. Davis, anything else from the state?
Just one quick note, I did attempt to make contact with the victim, the report, but was not able to contact.
Okay, meaning Ms. Katadia, who would have been the server, waitress, cashier at Waffle House. Thank you for making those efforts. All right. If you have no other questions, Mr. Williams, I hope very much that you are sincere about getting back to Maryland to help your dad, and I hope that works out for him and for you.
Yes, sir. Thank you, sir.
All right. And thank you to Macon State Prison. I know we started late and this took a long time, but it was important to resolve this. Appreciate your time.
Thank you.
All right. Bye-bye.
All right. That should mean that he is spending up until July. Then he got 3 years, but with credit of time served, which is from April 2023, which is 2 years and 2 months. So he has 10 more months, if my calculations are correct. But I assume that Attorney Wood here will fight like hell to get him over the border to Maryland. All right, folks. That is what I had for you. Court jumping a bit with Judge Simpson in the beginning and finished off with Judge McBurney. While I'm streaming from Rumble Studios. Now, tomorrow will be Friday. It is Slightly Buzzed Friday Law Show, and we will watch, if Prosecutor Love gets her shit together, we will watch the new RICO trial in Fulton County against Cash Out. And yeah, that will be interesting. That will be interesting. But again, folks, everybody, thank you for being here. Thank you for the support. Hit the thumbs up, subscribe if you haven't, all the YouTuber things. And Mr. Jimmy stepped away. But yeah, thank you. And I will see you all back here tomorrow around. I will start the stream around 1 p.m. Eastern time. Well, it depends if the RICO trial is going tomorrow. If it's not, I'm going to start closer to 4 p.m. All right. You all have a good one, and let's see, how am I supposed to get am I supposed to play this? I have no idea.